Hello, everyone. How's it going? This is immigration attorney Moumita. I am coming to you live to talk to you about immigration and to see the questions that you may have on your mind today. Thank you so much for joining me. My name is Moumita Rahman, and I am an immigration law attorney. I have been practicing immigration law for the past 14 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. So if you are joining me for the very first time, welcome to my live. I'm here to do the best that I can to put your mind at ease about your immigration process, to talk about the pitfalls and the hardships that you may be going through, and to see what options you may possibly have to move forward. So go ahead, drop me a line. Let me know what country you're from. Let me know what state you're living in right now. I always love to hear where my followers are from. And if you're a current client, thank you for saying hi. And I do have a very special topic that I want to start out with you today, which is what can you do if your spouse keeps threatening to cancel your case? What options do you have? And is there a way to move forward? So stay tuned. I'm going to go ahead and discuss this more in depth. All right, so let's get into it. What are your options if your spouse keeps threatening to cancel your case? First of all, this is something that is a situation that happens to a lot of people. If you come here, you get married to a citizen, or you were brought here by a citizen to get married, and you might find yourself in a situation where your spouse, every time you guys get into a fight, they keep bringing up your immigration case. They keep bringing up your immigration status, and they keep saying to you things like, "Oh, I'm going to cancel your case. You don't deserve a green card," or "I'm not going to go to the interview," or "You don't deserve a green card at all from me." What happens if you are going through the situation, and what options do you have, and how long will it take to get your green card if this is happening to you? So first of all, the bottom line is that if your spouse is sponsoring you for a green card, if your spouse has filed an I-130 for you and you are trying to get a green card off of this I-130, that I-130 is not actually your application. That is their application, and they have the right to cancel that, to withdraw that at any time, or to not submit it at all. So if your spouse does not, or if your spouse refuses to submit the I-130, or they want to withdraw that I-130 after they filed it, then you may have the option to do a self-petition instead by filing the form I-360 VAWA application. And the form I-360 VAWA application essentially replaces that I-130. And we want to file for VAWA in those situations where you are suffering in your marriage. Your marriage, first of all, you have to have a good faith marriage. Your marriage must be real, which means that you must have married for the purpose of having a life together, and that it was not a fake, fraudulent marriage, right? And number two, you must have suffered during your marriage. Now, how can your spouse simply threatening to cancel your case constitute emotional cruelty, extreme cruelty, and emotional abuse? Well, think of it this way. Your spouse realizes how important your immigration status is, and your spouse also realizes how vulnerable you may be without a green card. So when they threaten to withdraw, to cancel, to not do it at all, that is really playing with one of the most important things in your life as a means to control. So if that is happening, usually there are other things happening too. And for me, I have seen all these cases, and we have seen clear patterns of extreme cruelty. So that's one of the most important things that we have to do. So if your spouse is threatening to cancel your case, or to not file your case, or to not show up to the interview, you may be eligible to file for a VAWA self-petition. This is a brand new application that you can file that would essentially kick out that I-130 out the door so that you can do your case yourself and have full control over your own life and destiny. And that is what I want for my clients to have a fresh start, to have freedom, and to not worry about making their spouse upset and the consequences that it may have on their case. So if you want an evaluation, call us at 212-248-7907. All right, Amber, thank you so much. I just saw your review. Thank you so much. Our client Amber left us a wonderful review. Thank you. We really, really appreciate it so much, Amber. All right. Okay, so let's go ahead and answer some more questions live. Blessings. Hello. Nice to see you. Mas and Kwame from Ghana. Thank you. Nice to see you. Okay. Giovanni, hey. How long does an advanced parole take to be processed for a DACA applicant? Okay, so advanced parole is something that's called literally like a permission that's going to allow you to come back into the U.S. on travel from the US. And if you are a DACA applicant and you don't have a legal entry, now is the time to do advanced parole, because advanced parole is going to give you that stamp in your passport that you are missing right now. And when you have that stamp in your passport, it is going to help make certain immigration applications easier for you, especially if you get married to a citizen and you want to be sponsored by that citizen, okay? So if you want to file for a DACA advanced parole, I believe it's taking anywhere from, I think it's taking an average of 3 to 6 months to get. But obviously, if you have an emergency that's happening and you need for that application to be expedited, then you can always ask for any immigration application to be expedited if you can show that you have a legitimate emergency and if you have actual proof of that emergency. So you can call us Emily's 212-248-7907. How long does an I-485 take to be approved? From Davis Dookie. Davis, an I-485 can take anywhere from 3 months or 6 months to 3-4 years, depending on what category that you are doing your application on. Because when you file an I-485 for a green card, it could be because you're filing, you have an I-130 or a VAWA application or a T visa or asylum or a U visa. Now, generally speaking, what I find to be the case is that when you file any sort of humanitarian application like a T visa or a U visa or an I-485 based upon asylum, that will usually take several years to be processed. And I believe that's because maybe the immigration offices make that to be a lower priority on the line. But also where you live is going to determine how long your case takes to be processed, because I-485s can sometimes require an interview at the local field office, and some local field offices are very, very busy. Think of New York or Los Angeles. These are very, very busy locations for interviews, and it can take us a long time to get an appointment for an interview. If you marry the person in the country, what can you do to bring them back home with you from overseas? From Leo. Leo, this is a great question. If you are a U.S. citizen or a green card holder and you marry somebody in your country and you want to bring them to the U.S., the process to follow is going to be called an I-130 plus processing through the consulate, what I call consular processing. And this is going to be like a 3-step process. You usually have to file the I-130 first, and then you also have to do processing through the National Visa Center before you can go for an appointment overseas. If you need assistance, you can call us at 212-248-7907. John Brown. John Brown, thank you so much. John Brown's a current client from Jamaica, going through an abusive relationship. John, we are so happy to be here for you. Thank you so much for trusting us with your case. I just got my work permit and I advanced parole from VAWA case, but my VAWA case is still pending. Do I have to close DACA if I want to travel to India? From G. G, that's a very good question. If you have DACA, but you're also doing VAWA and you get advanced parole, do you have to close your DACA case to travel? And the general answer to that is that it is not required to close your DACA case if you get advanced parole through a different case and you want to travel on that. But definitely, if talk to your lawyer first to go over the implications and make sure that there's nothing in the way of you returning to the U.S. And if you're a current client, call our office first before you travel, and then we'll discuss. Okay. Chapater, I applied for N400 2 days ago and I got an email of biometrics appointment. How long would it take for an interview and test after the biometrics? From Chapater. Chapater, and anyone else who's waiting who has a question about how long your case is going to take for an interview, it always depends on where you live. Where you live and what your field office is going to determine how long you wait for your N400 appointment. I've been in the U.S. since 2007 and I was 6 years old. Do I have a chance to become a citizen from Double 350? Double 350, that is a really deep question. So for a lot of my people who are watching right now who have been in the United States since you were a child and you don't have papers, you're brought in, one of the most important things to look at is to see what you qualify for. Most of the times you may not have the option of any sort of family sponsorship because you don't have a citizen parent, you don't have a citizen spouse, But if you do have a citizen spouse, then they may be able to petition for you. But if you don't have that, then what we do at our office is we like to look to see what other humanitarian cases you might qualify for, such as a T visa or a U visa. Now let's talk about the T visa, because this is something that many people may be eligible for, but they just did not, they never knew what the T visa was. They never knew it to be an option. In fact, not a lot of lawyers actually screen for T visas, which is a real big shame, because the T visa is something that can help so many people get on a pathway to a green card. Now, at the end of the day, the T visa is going to give you a work permit. And once you get your T visa, you are automatically eligible to apply for a green card after 3 years. Sometimes we can even shorten that 3 years down by getting a special permission from the government and get you to a green card even faster. So the T visa is a way for you to get a green card, even if you entered illegally, even if you have no family to sponsor you, even if you have the permanent bar, or you have falsely claimed to be a U.S. citizen. The T visa is a way for you to get to be on a pathway to a green card. So what is the T visa and how can you qualify? Well, we call it the T visa, T for trafficking, because it is based upon something called human trafficking. But human trafficking in immigration is not the same as drug trafficking or narco trafficking. It is about when you as a person have been compelled and forced through force, fear, coercion to do some sort of work or provide some sort of service to someone. Now, I'll give you a few examples of our clients who have actually been approved for T visas and some of the loose circumstances that they were in. I'm going to try to describe it very vaguely so no one's confidentiality is violated. But for example, I had a client who worked at a nail salon, and the nail salon owner would not allow them to take breaks, would not allow them to have lunch, would not allow them to go to the doctor when they got a chemical splash in their face, and who constantly brought up immigration and screamed at our client in front of customers and other folks. And the client felt that they had no option but to work there and do everything the employer said. Now, why does this matter? When your employer is constantly screaming at you, threatening you, bringing up your immigration case, it makes you feel powerless. It makes you feel scared to do anything other than what the boss says. And that can lead to a situation where you are basically compelled to provide services at your job. And that is the basis upon which we won our T visa case. Next, we had a situation that was a lot more overt. We had a situation where somebody was a contractor, right? We have a lot of day laborers out here. We have a lot of construction workers watching right now. And in this particular situation, if you have been in a construction job where your boss, your foreman does not give you safety equipment, and you're doing work and you're like, well, where's my safety equipment? I'm scared to do this. And they say, you better do this right now, or I'm going to leave you on the streets. I'm going to call immigration. I'm going to get you deported. That's a very extreme situation, and that doesn't happen in every single case, but that's one example of what you can do. Now, I have seen video, look, anytime you have an employer who is screaming at you, calling you names, calling you nasty words, that is usually a sign of an abusive workplace. And if you are undocumented, this is something that we need to explore, because when words like that and threats like that are used against you and you become fearful of your employer, that is the start. That is what we need to start exploring for the T visa. So you can call us double 350 at 212-248-7907. There are lots of scenarios where this will happen. And what I like to explain to clients is, if you feel this is a trafficking situation, is not, people think that you have to be locked into a room, you have to be locked into a workplace in order to qualify for a T visa, but that's not true. I want you to think about whether you feel like your boss has put like a mental shackle on your head, where you feel like you cannot really make a move without their permission, or because you are afraid of them, okay? So call us at 212-248-7907. Chicks George, can you remarry if you are the spouse of a K-1 visa who refuses to file your green card after putting you through a series of abuse and files for divorce after they kick you out of the house from California? Chicks George, call us 212-248-7907. This is kind of like a classic example of marital abuse. If you were brought here on a fiance visa and your spouse refuses to file, you get married. First of all, we do have to make sure that you got married to your spouse, but it does sound like you did. If you got married, your spouse does not want to file your green card, they kick you out. But they're the ones that brought you to the US on a fiance visa. This is going to be a classic case of marital abuse. So call those checks. You may be still eligible to file for a green card by yourself through VAWA. Even if they filed for divorce, if you've already gotten divorced from your spouse, then we have a deadline of 2 years to file for VAWA, okay? And if VAWA does not end up being an option, then we'll look to see if maybe you might qualify for a T visa. We have definitely seen lots of people come here on fiance visas and they get treated like a servant by their spouse, Sometimes they expect you to do all the cleaning, cooking, they send you out to work and they take all of your paycheck earnings. This may be a trafficking situation too. So call us, chicks, 212-248-7907. If you're married to a citizen, how long will it take to get a green card? That depends on, number one, do you have a legal entry or an illegal entry? Number two, where do you live? Do you live in a busy location or do you live out in the suburbs somewhere where there's less cases? And number three, do you have any complications in your case that require an interview, like misrepresentation or fraud, et cetera, et cetera? It can take anywhere from 6 months to several years. Can I petition for my family over 21 from Badgal Michi? Badgal, if you have a son or daughter that is over 21 and you want to petition for them, yes, you can. However, it can take like 10 to 15 years because if you're a U.S. citizen and you have a child over 21, they are no longer considered to be an immediate relative, and they now have to wait in line for a visa according to the visa bulletin. Watch out for my video on YouTube that's coming out on Monday, hopefully, where I talk about the visa bulletin and about what sort of family members that you can sponsor. And also, just a request to you, please subscribe to my channels. Find me on YouTube. I have a lot of very long videos where I try to educate you. The more subscribers and followers I have, the easier it becomes for me to make videos to help you learn about the immigration system. Okay, so to go back to your question, Badgal, you can petition for your family, but their options are going to be a little bit more limited. And if they are already in the U.S. and they're out of status, that's another problem. They'll probably need to leave the U.S. to do processing, and they might need waivers. And I would say to call us because maybe we can independently evaluate whether your child has any other options of their own, okay? Can we apply advanced parole for a valid application that is pending? Please answer. Anupa, if you are not in removal proceedings and you don't have a removal order and you are filing for VAWA, then generally speaking, yes, you may be able to file for advanced parole. Now, whether or not you should travel is going to be something that you need to discuss with your attorney's office any single time that you plan on traveling, even if you have advanced parole. I had DACA, but I missed my renewal. I married my husband and filed a petition. Will the fact that I had DACA for so many years help the approval of my marriage petition from YMD? YMD, thank you for your question. It's a very good question. If you had DACA and you are now filing for a marriage petition, does the very fact that you had DACA help or hurt your application? And the answer is that it doesn't really do anything, actually, YMD. But it can be used to show that if you ever, what I would say, actually, here's what I would say. If you have ever filed any sort of immigration applications in the past and you're now filing for an immigration application, one thing that I can say is be very careful, YMD, about what you have submitted in the past to make sure it does not contradict with any information that you are filing with your marriage petition. Sometimes I see this be a problem. Like, let's say if you if you entered, on a certain date, or if you went back and forth, if you give information about your illegal entry to the US, and then later when you do your marriage petition, it's a different information, it might create a problem. So it can sometimes actually hurt if people are not careful and they don't realize what they've said. But generally speaking, it doesn't really help you. However, it's not a bad thing. All right. It's not a bad thing. Michael Reach, congratulations. Michael has been approved for his green card through VAWA, and he wants to know about how long he has to wait to apply for citizenship. Michael, you get to apply for citizenship 2 years and 9 months after you get your green card, because when you get your green card through VAWA, you are eligible to utilize the 3-year rule for applying for citizenship, okay? Jacinta, can you travel after a T visa approval? Jacinta Kimani, yes, you can, but you need to apply for something called advanced parole after you get your T visa. Once you get that advanced parole, then you may be able to travel, okay? Junia, me and my husband are separated but not divorced yet. Can I file for VAWA if my marriage was abusive? And is divorce required for VAWA? From Junia. Junia, thank you for your question. It is a great question because many people wonder, do I actually have to be divorced to file for VAWA? And the answer is no. There is zero requirement that you be divorced from your spouse when you file for VAWA. In fact, we have filed for and gotten approved VAWA for people who are still living with their spouses. Here is what I would say to you. Marriages are very complicated. Even if your spouse is hurting you, you may not be in the right mindset or in the financial situation or in the social situation to actually divorce your spouse or move out. That is not required to file a VAWA case. Just because you are still living with your spouse or that you are still married to your spouse does not delegitimize the fact that you have suffered in your marriage. And that is all that we care about in a VAWA case. So Junia, you can call us at 212-248-7907. I want to help any of you out there who have been withholding from filing for VAWA because you think that you don't have enough proof. You are still married. What is the government going to say? Are they going to believe you or not? Who cares? We believe you. We believe you. And people, you do not need to worry about the evidence that you have. We have gotten cases approved on just clients' affidavits. Now, of course, if you have evidence, we want to use it and we want to use good evidence. However, VAWA has the standard of any credible evidence standard, which means basically that your words alone are enough to win a VAWA case. And if you are worried about filing with just an affidavit, you can do a psychological evaluation. You can get witness statements. There's different ways that we can help prove your case, okay? All right. Ishwar, thank you. Jay Jara, thank you. Nice to see you. Another one of my clients. How do I deal with an estranged husband who never filed for me and now wants a divorce? From Rufaro Page. Simple. Page, you ignore them and you file for VAWA. Okay, all right. Sorry, I'm laughing because divorce is one of those things that your ex-spouse tries to use to control you too. Even though like they haven't filed for you, it's such a funny situation to be in, right? Like they won't file for you, but they won't let you get a divorce either, or they're going to force you to get divorced, because of whatever reason. And you should answer the divorce summons, of course, because, if your spouse serves you with divorce, even if you don't answer it, the court can still give a divorce. So whether you choose to answer it or not is up to you. However, default judgments of divorce do happen. And for those of you, who want to file for VAWA, if you were given a divorce summons many years ago, you need to call the court to see what happened, because that might affect your deadline for a VAWA case. But if you're in a situation, Rufaro Page, where your husband is estranged from you, they never filed for you, and now they want a divorce, that's okay. Go ahead and do that and move on with your life, and call us at 212-248-7907, because we want to see if we can help you file by yourself instead. Even if they didn't file for you, that doesn't mean that you can't file for yourself. And let's talk about what you just said right there, that your husband is estranged from you, which indicates to me that they left. And let's talk about spousal abandonment. Is spousal abandonment enough for a VAWA case? Spousal abandonment by itself is not enough, but spousal abandonment is usually a sign of emotional abuse. And where there is spousal abandonment, there are other things that have probably happened. So that's why I would say to call us to see if we can help you file for VAWA, okay? 212-248-7907. Hi, Palos. My TV is a client in California. Hi, nice to see you. Okay, this is a very good question. I have a question about the T visa. Will the employer be notified of what's going on from Danny D? Danny D. Danny D, if you are filing for a T visa, will your past employer or current employer be notified? And the answer is not really. So this is what happens. When we file for a T visa, we have to make some sort of a law enforcement reporting. And all that it means really at the end of the day, the shortest way, the quickest way to do that is to just notify the Department of Labor or the Department of Justice or the FBI that you have been the victim of a trafficking situation. And then it is up to them about whether they investigate or not. Now, normally the first thing that they do, if they want to investigate, is they would call you for an interview. A lot of times we do these interviews by phone or by Zoom. Sometimes we might go in person depending on what agency we choose, but they interview you first to find out the facts, and then they decide whether or not they want to take it a step further and maybe investigate the employer. They have a duty of confidentiality to you in these cases. They cannot, you're a victim, so they can't just disclose your identity because you have a risk of retaliation and other harm that you might suffer. So they are not allowed to do that. Okay. And it's making a law enforcement reportment is not the same thing as pressing charges. If you press charges like in a court of law, then you would most likely have to reveal your identity because it's a court case. But this is not the same thing. So T visa, abusive employers upon whom we file for a T visa are not notified about your identity, okay? And if that's been your fear, if that's been holding you back, call us at 212-248-7907. If you have been in a T visa situation, you don't have any other options, I will also want you to consider what it really means if they do find out. You are going to be on the path to freedom, right? So how much will that matter? Now, also, what I would say is if you are so afraid that your employer will find out that you have filed for a T visa or that you've reported them, that is also an indication to me that you are eligible. You are more than eligible for this case. That sort of a fear doesn't come from nowhere, okay? 212-248-7907. I've just filed and I want to know how long would it take to get my work permit or green card from Yasin. Yasin, I would say normally speaking, work permits are taking 6 to 10 months. I originally came on a visitor visa. Will I still qualify for a T? If so, what evidence do I need to prove that I was coerced into staying in the US to qualify for the T visa from Elizabeth? Elizabeth, great question. You can qualify for the T visa no matter whether you entered with a visit visa or illegally through the border. That doesn't matter. You can still qualify for the T visa even if you have an order of deportation already. That does not matter. Now, in order to qualify, the evidence that you will need is yourself, because just like with our VAWA cases, the most important evidence that we have in a T visa case is you. And that is why we work hard to make sure that we do your affidavits properly, we get your correct statements, and show through what you have said and what you have experienced, how you happen to be put into a state of involuntary servitude through your employer or your partner's, force, fear, fraud, lies, whatever that they use to get you to stay in the US and to do work. Now, that's the other element that we have to show in a T visa case is we have to show what you did. What did you give? What did you give because you were induced to give that through fear or fraud or force, right? Sometimes you give your services, you give your work. Sometimes you give your body, you provide sexual services. There's lots of things that can qualify for this. So call us at 212-248-7907. How long does your office take to prepare a VAWA case from Rubric? Rubric, a good VAWA case will take us up to about six months average to prepare. If you want to make an appointment, you can call us at 212-248-7907. There are no in-person appointments, so please don't show up to our office. And the appointment is with my legal team and not me. Is there any way to help a mother from daughter to mother to fix legal status? From Soto Amy. Okay, so Soto Amy, I think you're trying to ask, you're a daughter, you want to help your mom fix her status. So that's a good question. So I think that's what your question is. And if that's what you're asking, then if you want to help your parents fix your status, that is wonderful. And I really, this is something that is so important in our society. However, your ability to fix your parents' status is going to depend on how your mom or dad entered the country. If your mom or dad did not enter legally through the US, and they had only one illegal entry into the US, then we can see if they might qualify for something called Section 245I, adjustment of status. That is available to people whose, brothers or sisters or moms or dads, or like a boss from a long time ago filed an application for them before April 30th, 2001. If they did, then we may be able to claim Section 245I, adjustment of status. If that never happened, then we can look to see if you're in the military or if they might qualify for military parole in place. Yes, those are the two main things. And that is going to essentially, if they're eligible for one of those two things, then we essentially can use that to erase that illegal entry into kind of like a legal one so that you can do a green card for them. But let's just say you don't have that, they don't have that. And also they have something called the permanent bar. Now, the permanent bar happens to people. It is a punishment. It is a castigo that is put on people who have gone back and forth across the border multiple times. But there's two things that basically must happen. Number one, the permanent bar gets triggered upon somebody when they have been in the US for more than 1 year in total, cumulative 1 year in total, and they attempt to re-enter the United States illegally without permission after April 1st, 1997. So if your mom came to the US in 1988, but then in 1996 they go back home, and then they come back in 1997, that may trigger the permanent bar because they already had that one. Depends on when they come back, because unlawful presence in reality was created in April 1st, 1997. So unlawful presence starts on April 1st, 1997. Also, if they had a removal order and they come back illegally without permission after April 1st, 1997, that may also trigger the permanent bar. So if your parent has a permanent bar, then what we like to look at in our office is to see if, they have any kids that have caused them to suffer. So if you have a brother or sister that's been like this rebellious person that has been in a lot of trouble, that, screams and curses at your parent might qualify for VAWA based upon them. Number two, they might qualify for a T visa, or they might qualify for a U visa. And those are not cases that you would be able to help them with directly. However, it is still possibly a pathway to them. And the only way to find out if they might qualify is to actually do a case evaluation. So call us 212-248-7907. Okay. All right. Ok, desde Dara Catherine. Dara me pregunta, necesito divorciarme, pero tengo miedo de volver a mi país, Colombia. ¿Puedo aplicar a un asilo? Tengo pruebas de medicina legal. Y pruebas de haber sufrido violencia. Ok, Dara Caterina, muchas gracias para su pregunta. ¿Puede usted calificar para asilo? Y estos son los, los elementos que necesitamos para probar que usted está calificar para asilo, ¿ok? Número 1, necesita un miedo de regresar, pero este miedo tiene que ha sido, ok, lo siento, mi español es un poco malo. Para asilo, tiene miedo de regresar basado de su religión o sus opiniones políticas o de su etnia o depende de su de que usted son de un grupo que tiene tratamiento que ha sido okay, I can't speak it at all. Okay, Caterina, let me return to your question. Okay, para aplicar asilo. Para aplicar en asilo necesita prueba, sí, necesita prueba de su violencia, pero la cosa más importante en asilo es la razón que de que tiene miedo para regresar. Si tiene miedo de violencia general, no es suficiente, pero necesita miedo de regresar de violencia para razones particulares, ¿ok? Lo siento, mi español necesita mucho trabajo. Can a prisoner get married to an undocumented person and get them their papers if they're in prison from Puerto Rican tone? Puerto Rican tone, I think you mean like, can you as a US citizen get married to somebody in prison and get them papers? And the answer to that is going to be, it sounds unlikely. If someone is in prison, that means that they have been convicted of a pretty serious crime. So just marrying them alone may not help. They may need to have certain waivers. They may not be eligible. They may they may have an aggravated felony that requires them to be deported after prison. So that is something to consider. But the best way to find out is to do an analysis on their actual conviction. I got my EAD combo based on VAWA 1 month back. I want to know when I can get the green card, how long to get the green card. The green card will probably take another 2 to 3 years. Hi, Samantha. Is it safe to travel on advanced parole? Generally speaking, if you do not have any criminal convictions, it's okay. However, you need to talk to your lawyer's office to go over it to make sure that there's not going to be problems. Now, anytime that you travel on advanced parole, you will be put into something called secondary inspection, and you'll have to answer some questions, and your lawyer's office will hopefully help you prepare for that. And hi, Samantha. Hope to hear from you soon. Desde Man, me acabo de casar, mi esposa es ciudadana. ¿Cuánto tengo que esperar para poder aplicar para la residencia? Ok. Si usted está casado con un ciudadano, generalmente su caso va a tardar más o menos 6 meses a 1 año o 2 años, depende en dónde está ubicado, porque todas las oficinas todas las oficinas de inmigración en los Estados Unidos tiene tiempos diferentes para programar por una cita y una entrevista. If I were able to house displaced illegal immigrants, how would the government address them approaching citizenship? Will deportation be their first position? Well, anytime somebody doesn't have any permission to be here, then the government can put them into deportation proceedings. So at the end of the day, just because somebody is here doesn't always give them the legal permission to be here. And if you don't have a legal permission to be here, then depending on how aggressive the government wants to be, they can put people into deportation proceedings. Al-Bayanat, if you have remarried and you had a pending I-360, then the bad news is that your remarriage will actually disqualify you from seeking VAWA. Does a T visa have a premium processing? It does not. If you have a T visa, you can also file for derivative status for your children underneath 21. Over 21, they may be eligible too, depending on if they can satisfy some requirements. Mark, thank you so much. Oh, hello, Mark. Thank you so much. If I can't afford your fees, can I do VAWA on my own from John CV? John CV, yes, definitely. So here's the thing. People do ask me this a lot, like if I can't afford any legal fees, can I file for VAWA on my own? And the answer is yes, of course. You can actually file for any immigration benefit by yourself. And if you truly cannot afford fees, there are lots of resources out there. There are resources on the government's website itself that tell you how to file. There are nonprofits that may be able to help you. So you're not going to be totally alone, but it's going to take more time and more effort on your part. So I definitely encourage you to look up certain organizations like Este or even organizations like Catholic Charities, Legal Aid. They can sometimes help you file these applications too. Al-Bayanat, thank you. So going back to your question, Al-Bayanat, if you had your I-360 pending, you need to understand and make sure you remember that if you are filing for VAWA based upon abuse from your spouse, you cannot remarry. Even if you're divorced, you have to wait to marry a new person until after your I-360 is approved. Now, if you have gotten a notice of intent to deny, the number one, is it true? Did you actually legally marry somebody else? If you did not legally remarry somebody else, then you can show them proof about that and then try to dispute it. But if you know that you did, then you need to take a step back to see what other options you might have at this point. Okay, I hope that helps. Javier Chico, what do I need to do if I check my status of my I-765 and it says the card was mailed to me and I already waited like 40 days? ¿Qué debo hacer? ¿Qué debo hacer? Okay. Javier, I'm going to answer this. Voy a contestarle en inglés porque mi español necesita mucho trabajo. Pero si su online status decir que su tarjeta ha sido aprobado, pero fue mucho tiempo desde el aprobado, pero no ya ha recibido su tarjeta, necesita llamar a UCIS, a el Customer Service. El número es en el sitio, pero necesita llamar a UCIS y para buscar qué sucedió, porque hay una posibilidad que su tarjeta está perdido. Y sí, la situación es una peña y es un, I don't think I said that word right, but pero necesita llamar a UCIS, okay? So if you have gotten the status online that says that your work permit has been approved, but it's been 40 days and you still have not received your work permit, you need to call USCIS and inquire about what happened. Sometimes, unfortunately, cards can get lost in the mail. And if that happens, that's a really sad thing because that means that you might have to reapply a second time, okay? All right, guys, that's all the time that I have for today. Thank you so much for joining me. I hope this helped. I'm sorry to everyone's ears for my bad Spanish. Romer is asking, can you make a video speaking about the differences between the T and the U visa? Romer, definitely, I'll put that on my list. Thank you for joining. If you're an immigrant, keep your head up high. You will be okay. Okay, and the most important thing is that you understand what options you might have. If you are qualified for something, then take that chance and apply for it to secure your status. Even if you don't qualify for anything now, keep your heads up high. You belong in this country. You've been working hard. You add to the fabric of the society. So never let anyone tell you otherwise, okay? I hope you all have a great day, and I'll see you again soon. And for an appointment, you can call us at 212-248-7907. See you soon.